Welcome. We are visiting the values of the Constitution of India. Our focus at present is about the legislative domain, the distribution of legislative sovereignty under the Constitution, the union of states. So, as union, parliament, and as state legislatures have been made as two different legislative sovereigns, the concurrent list is the list under which both union parliament and state legislature can legislate. List 1 is exclusive for the union parliament, list 2 is exclusive for the state, but state and union both are having powers to legislate in respect of the entries of list 3. This list is called concurrent list. Now, this list deserves to be analyzed, deserves to be comprehended, deserves to be imbibed from the point of view of judicial organ, justice systems, functional. The union list is exclusively having a legislative sovereignty over the heads of list 1, but simultaneously union list is also having demarcated power to define offenses. So the crimes with respect to the entries of list 1 are legislated by union, and with respect to the list 2, the states define the crimes. Therefore, the concurrent list as such is indicating that let there not be any gap with respect to the crimes. So this list that way becomes more important, as it is here where the list of the criminal law, including all matters included in the Indian Penal Code at the commencement of this constitution, but excluding the offences against laws with respect to any of the matters specified in list 1 or list 2, and excluding the use of military, naval, and all that. This very first entry well indicates that the constitutional policy has been that let there not be any gap with respect to the crimes which deserve to be dealt with by the Indian states, Indian parliament. So we, the people of India, have adopted and given to ourselves a constitution to ensure that as far as the crimes are concerned, there does not remain any gap. Let a crime which is not coverable by the entries of list 1 or of entries of list 2 shall also become the specific subject matter of legislation, and as such the very first entry of list 3 is very important from the point of view of criminal law systems. So the very first word is criminal law. Criminal law, including all matters included in the Indian Penal Code at the commencement of this constitution. As such, the Indian Penal Code has been taken as a reference point, and the first entry conveys criminal law including all matters, means there can be matters over and above the set of the matters covered by the Indian Penal Code. So, criminal law, including all matters, the word including all matters, this phrase very well makes it explicit that the criminal law being conceived by this list is that it is to cover all the matters of Indian Penal Code, but these are not the only matters. There could be more. So criminal law is very exhaustive phrase, and it includes Indian Penal Code, which was at the commencement of the Constitution. But excluding offences. Now see, this power of first entry of the concurrent list as criminal law excludes the offences with respect to list 1 or list 2. That means the list 1 offences remain within the exclusive legislative domain of Parliament. Offences of list 2 accordingly are parallelly with only the state legislatures. So we have to visit these legislative entries as per their expression, and it is here where we will be benefited to imbibe the values of this policy of separation of legislative powers. There is a separation of legislative powers, but still every care has been taken that there remains harmonious, continuous, and exhaustive coverage for the crimes as far as the criminal law is concerned. Now, let us see that this concurrent list is having 47 entries as these were enacted at the commencement. However, this list has been amended, as has been shown in this expression sheet, that with effect to 3rd January 1977, there were amendments as per the Constitution 42nd Amendment Act and Section 57 of this Amendment Act and the Section 2 of 1954 Amendment Act have made amendments in this very list. Therefore, this list as stands amended is having about 50 entries. Let us first of all have a overall view of this list and then to analyze each and every entry to understand its implications, to understand its values, to understand how these powers in fact have been exercised and different laws have come into force. The first entry is criminal law and the second entry is of the criminal procedure. Third entry is preventive detention for reasons connected with the security of the state, the maintenance of public order, maintenance of supplies, services essential to country, and persons subject to such detention. Fourth entry is removal from one state to another state of prisoners, accused persons, and persons subjected to preventive detention for reasons specified in entry 3 of this list. The fifth entry is marriage and divorce, infants and minors, adoption, wills, intestacy, succession, joint family, and partition, all matters in respect of which parties in special in judicial proceedings or immediately before the commencement of this constitution subject to the personal law. So the personal law as such has become the subject matter of legislative domain of union as well as of the states. This entry regarding personal law as such gives us clear insight that the Constituent Assembly was very much conscious as that as far as the personal laws are concerned, for which both state and union will be having equal concerns, responsibilities, and duties. We know that our principles of state policy, directive principles of state policy, provide for a uniform civil code, which means that there will be inclusion of the personal law in a uniform code expected under the directive of state policies. Therefore, when a uniform civil code will be enacted, then the same as such is to be covering entry 5. And we know in Goa there is a uniform civil code. However, in other states and other parts of the country, this uniform civil code is not there. Therefore, the importance of this entry in concurrent list is well demonstrated as far as the case of Goa legislation is concerned. Then transfer of property. Other than agricultural law, registration of deeds and documents, the transfer of property with respect to the agricultural lands and with respect to other lands have been segregated. Entry 6 is only in respect of transfer of property other than the agricultural land. Entry 7, contracts including partnership, agency, contracts of carriage, and other special forms of contracts, not including contracts relating to agricultural land. So we know that the law of contracts has been a uniform enactment. It also covered the partnership agency aspects as well. Then subsequently, the Partnership Act has been segregated and has been made an independent act. Now, this entry will give us clear insight as that the subject of contracts will have many features, different spectra will be there, and as such, there is bound to be difference of the values. These different states may have their different values with respect to this relationship. And so this area of law, as this entry has been made subject of concurrent list. Let us now see the further the actionable wrongs, bankruptcy and insolvency, trust and trustees, administrators general, and official trustees. See the category. How big is the category which has been put under the concurrent list? Then administration of justice, constitution and organization of all courts, except Supreme Court courts. The subordinate judiciary is made subject legislation of a concurrent list. When we think of, when we conceive, when we propose that there should be all India judicial service, then this will be covered by this 11A entry. This is an amendment. So previously, this entry was not there. Now, subsequently, there has been amendment, and this new entry has been included. And this entry, as it is about administration of justice. So, justice systems basic core as administration of justice, constitution and organization of all courts. The word used is all courts except the Supreme Court and High Court. That means the entire subordinate judiciary domain is within the state and union. Both union and state have been given sovereign legislative powers and responsibilities under this entry. So you can see that whenever there will be an attempt to create All India Judicial Service, then this entry will come into play. And also from here, we can well visualize that even when there will be an All India Judicial Service, still there will be special judicial services as well, as each state may, because of its own peculiar setup, will feel the necessity and will justify the creation of special judicial services. Moreover, the complexity of human life, the complexity of activities as well will demand that there shall be very different setups of judicial services. Reading ahead, evidence and oaths in the civil procedure, contempt of court as well have been put under this list. Step ahead, the vagrancy, nomadic and migratory tribes, leniency, mental deficiency, prevention of cruelty to animals, forests, protection of wild animals and birds, adulteration of foodstuffs and other goods, drugs and poisons subject to the provision of entry 59 of list 1 with respect to the opium, economic and social planning. See, the economic and social planning is the domain which is the value in the preamble itself. The preamble of our constitution well ensures justice, economic and social, both aspects are covered. Therefore, the economic and social planning becomes the joint responsibility of the union and the states both. Step ahead, population control and family planning. See, here as well, both parliament and the state legislatures are vested with the responsibilities. Let me proceed further. Commercial and industrial monopolies, combines and trusts, trade unions, industrial and labor disputes, social security and social insurance, employment and unemployment, welfare of labor education including technical education, medical education, and universities subject to the other provisions, legal, medical, and other professions. Relief and rehabilitation of persons displaced from their original places, charities and charitable institutions, prevention of the extension from one state to another, vital statistics, ports and ports other than declared by or under law made by parliament or existing law to be the major ports, the shipping and navigation of the islands, trade and commerce. See how big domain of entry 33, which also has been subject of amendment. So this domain of trade and commerce and the production, supply and distribution. And then 33A gives weights and measures. Then price control. See, price control is given sovereign legislative powers and responsibilities both to state and to the union. Then the mechanically propelled vehicles and factories, boilers, electricity, newspaper, books and printing presses, archaeological sites, custody, management and disposal of property, including agricultural land, declared by law to be a vacuum property, acquisition and requisitioning of property, acquisition and requisition of properties, recovery in the state of claims in respect of taxes and stamp duties other than the duties or fees collected by means of judicial stamps, but not including rates of stamp duty, inquiries and statistics for the purpose of any of the matters in list second or list third, jurisdiction and powers of all courts except Supreme Court with respect to any of the matters in that list. So here, jurisdiction and powers of all courts except Supreme Court means jurisdiction and powers of the high courts as well are within the union as well as within the responsibility of the concerned state as well. Fee in respect of any of the matters in the list, but not including fees taken in any court. These entries, as these are, deserve to be visited more than once, and then big coordination groups are to be formed to have a clear and comprehensive view of this legislative domain, as the same will be required at many occasions as subject of concerns, issues of interpretation, and for it many times courts have to intervene as it is basic concern of powers of states as well as it will be concerning the duties and responsibilities of these functional operators, and the individuals as citizens are naturally deeply concerned with their rights and their activities and promotions. Now, this set of domain deserves to be compared with the union list as well as with the state list, because there is bound to be some overlapping with respect to certain legislative domains. And as both state and parliament have been vested with the responsibility and the duties to legislate, so there is bound to be difference of opinions, and at many times different stands may be taken. Some clash at clashing points. Conflicting stands also are bound to occur. Therefore, these lead to many times very, very complicated litigations. We as lawyers are certainly deeply concerned with the interpretation of the domain of each and every entry. Each entry deserves to be taken up as an independent domain. And as each entry is an independent domain, therefore, different domains interpretation is bound to confront us where there may be overlapping or there may be a clash. So it is a very big domain. Interpretation is the basic concern. Well demarcated features of each entry are to be imbibed, and this as such is certainly going to be a very, very big, complex domain to be entered upon. The constitutional lawyers and the constitutional courts are certainly very deeply concerned with it, but otherwise, at subordinate courts litigations as well, in many situations, this demarcation of the legislative powers may raise very serious issues. We know that interpretation of law as such is beyond the jurisdiction of the subordinate courts. And as we have seen earlier, there are provisions in the procedural codes that when such issues of interpretation of the legal provisions comes in, then the references can be made by the subordinate courts, the High Court. So how this reference is to be maintained, how the question is to be drafted, how the reference is once made is to delay the trial proceedings or immediate concerns. We have to be very, very cautious in having references of interpretation. Certainly, the interpretation references have very serious and very immediate impact on the outcome of adjudication of trials in the subordinate courts. Therefore, this responsibility of remaining alive to the interpretive responsibilities is to be accepted by all of us, may it be at the subordinate courts level practice or at the higher constitutional courts the art and science of interpretation of statutes, art and science of interpretation of the Constitution, the art and science of interpretation of the legislative domain. Entries of these lists is a very delicate discipline. We have to learn this art. We have to imbibe the values of this art, and it is going to be a very blissful learning, and it is going to be very fruitful as well. Thank you very much.
Thank you, sir.